2, 1.
This Honorable Court of Tennessee is now in session.
Good morning to the attorneys. Just a couple of things before we proceed. We will be proceeding as if we were actually in court, except you will not need to stand during the presentation of your argument. The next thing, if there's any technical matters that develop, please let us know immediately so those can be taken care of. I understand that the appellant has already reserved their time. If there is nothing further, then we can prepare to proceed. Madam Clerk, will you please call this case?
Wilmington Savings Fund Society, FSB et al. Versus Thomas S. Jackson.
For the appellant, you may proceed with your argument, sir.
Good morning. Robert Lieber on behalf of Wilmington Savings Fund Society, FSB, not in its individual capacity, but solely as certificate trustee of Bosco Credit 2 Trust Series 2010-1. May it please the court. This action was initiated by the plaintiff appellant based upon defendant's failure to make payments under an installment note, and the complaint was filed for breach of contract. The parties agree that the last payment under the note was made in 2007. After the filing of the complaint, the defendant, Mr. Jackson, filed a motion for summary judgment. The motion for summary judgment contained an affidavit by Mr. Jackson, which stated, the original lender sent to me a notice of default and notice of acceleration in or about year 2008. And this statement, this part of his affidavit is really the crux of this appeal. The defendant, Mr. Jackson, alleges that due to this alleged notice of acceleration in 2008, that the statute of limitations ran 6 years after, sometime in 2014. The appellant argues that the bare statement made by Mr. Jackson without actually including the notice of acceleration or any other evidence of acceleration is insufficient at a summary judgment stage to show that the note was in fact accelerated at that time.
Mr. Lieber, I have a question. This note was to secure real property, is that correct?
I don't believe that it's in the record that it was to secure real property, but it was, yes.
But somewhere I read that the property was foreclosed on, so I wasn't sure if what you all were seeking it was the deficiency judgment, if you're seeking the balance on the note.
This was actually a 80-20 loan, that's my understanding. And so if there was a foreclosure, it was on the primary, the first lien, and then my client is the owner holder of the second note, which was the 20% portion of the loan, and they're seeking the outstanding balance on that loan. Again, this hasn't been argued, but just to fill in the blanks here, the foreclosure obviously did not satisfy both notes. There weren't enough excess proceeds to satisfy my client's outstanding balance at the time of the foreclosure.
All right.
And I don't think Mr. Jackson has argued that point that the foreclosure sale would have extinguished my client's lien or ability to pursue a judgment for the outstanding balance of the note. The most important thing from my client's perspective with respect to the motion for summary judgment is that since the motion for summary judgment was filed by the appellee, Mr. Jackson, who was the defendant in the Chancery Court, the burden was on Mr. Jackson to show that the statute of limitations had run. This court has said that when a defendant moves for summary judgment on an affirmative defense, that is first their burden to meet all elements of that defense. And so it was incumbent upon him to show that the note was accelerated in 2008. As I've already said, the motion for summary judgment did not include the notice of acceleration, so neither the Chancery Court nor this court can review the notice of acceleration to investigate what it actually says. And there is the main issue with Mr. Jackson's argument. This is because him just saying that he received a quote notice of acceleration is insufficient. There's no case directly, at least there's no case from Tennessee state courts that are directly on point, but we've cited multiple cases in the appellant's brief that show that the language in a notice of acceleration is extremely important. Just because something is titled as such, one, doesn't even mean that it is actually a notice of acceleration. For example, the Kreider v. Rogers case, which was a Tennessee federal case, required the court to actually inspect the letter that was being alleged as a notice of acceleration. And then after it inspected that letter, it said, no, this didn't actually accelerate the subject note. It may have threatened to accelerate the note, but the language did not make it clear that the entire balance, then due and owing of the note, was accelerated at that time. And other courts in some of the other cases that I've cited have said that because the full acceleration of a note is such a serious remedy that it needs to be clear in order to favor the borrower that they now owe the entire amount that is due. Another case that I cited was the Merceri versus Bank of New York Mellon case that was out of Washington. And it was a very similar situation to the Kreider case, where the borrower alleged that there was a notice of acceleration and that the loan was accelerated and therefore the statute of limitations had run. But again, they submitted this notice and the court looked at the notice and said, well, it's not actually accelerated. Again, there might be the words acceleration or accelerated, but that in and of itself does not mean that the acceleration actually happened. And again, here, all that we don't even have the notice of acceleration. All we have is a statement from Mr. Jackson saying that he received a notice of acceleration. The problem here is that Mr. Jackson, one, is not an expert, and he's not a lawyer, at least not to my knowledge. And so
your client denied the acceleration.
Yes, my client, in the motion for summary judgment, in their response to the defendant's statement of material facts, disputed that it was accelerated in 2008 and said that it was only accelerated upon the filing of the complaint. And I know Mr. Hall will certainly raise this, but there was not an affidavit from my client in the response. It was simply the response to the statement that said it was denied and that it was the filing of the complaint that actually accelerated the balance for this particular note.
What's in our record from your client as far as this note is concerned? That is an affidavit as far as this note is concerned. in response to this motion for summary judgment?
I'm sorry, Your Honor. I broke up a little bit when you first started your question. I'm not
What
sure
did
I
your client
followed.
file a record in response to this motion for summary judgment?
The response was more, well, let me first start by saying this. The motion for summary judgment did not indicate which statute of limitations the defendant was relying upon. The response contained more legal argument. There were no, at least to my knowledge, and Mr. Hall can correct me if I'm wrong, additional documents attached to my client's response to the motion for summary judgment. But again, I would go back to the point I made earlier that the burden was on Mr. Jackson to prove that the note had been accelerated. At that point, he failed to do that because there's no clear evidence of acceleration. His standalone statement.
Yeah. Do you have any cases that say that his affidavit testifying basically that the note was accelerated is incompetent proof? It would seem to me that he's raised the issue, he submitted an affidavit. The respondent's responsibility is then to show through affidavits or other evidence that that fact is disputed. I mean, is there some reason why we cannot rely on what he has stated happened?
Sure. Well, first, you actually brought up a point that I was going to mention, which is Mr. Jackson hasn't put forth any case law that says his affidavit alone is sufficient to show that the acceleration has occurred. And the cases that I've cited in my brief, the Snyder versus Emergicare is a Tennessee case where two doctors submitted an affidavit saying that such and such was the proximate cause of an injury, but they didn't actually provide concrete facts to support that legal conclusion. And so what we have here is very similar, because what Mr. Jackson said was a legal conclusion, that the note was accelerated. That is in and of itself a legal conclusion. And he, without providing the factual support for it, such as the notice of acceleration itself, is simply making a legal conclusion, which in an affidavit is inadmissible evidence. I find it akin to, and I know it's a slightly off-topic analogy, but if someone were to submit an affidavit saying that they were assaulted, well, I don't know if a court could say that is enough to say that an assault, as it's legally defined, actually did occur. You would need to say, well, this happened, I was touched in this manner, I was yelled at in this manner, or these things happened. It's very similar here, where he's just saying a notice of acceleration without even providing the substance of that letter or providing the letter to show that it was in fact accelerated. Thank you.
Okay, thank you. You have your rebuttal. Yes, sir.
May it please the court.
Go right ahead.
May it please the court, Your Honor, and good morning. Scott Hall on behalf of Thomas Jackson. The facts in this case, of course, and the timing are critical, because the issue that is being considered is the running of statute of limitations on the claim that was asserted by the plaintiff. Mr. Jackson, my client, did present evidence with regard to receiving notice of acceleration. And I submit to the court that that is a factual issue, that it was not contradicted. No countervailing evidence was presented by the plaintiff appellant in this action. It's important that we recognize, and it's fairly simple in terms of the timing of this matter, greater than 11 years passed since this notice of acceleration was received before the lawsuit was filed. So there's no question generally, and I say generally without citing the statute, but we've got that in our briefs. The 6-year contract statute of limitations ran, and the general overall catch-all statute of limitations of 10 years in Tennessee was applicable as well. The plaintiff produced no evidence to contradict the timing of the acceleration. There was nothing, and the court asked whether or not something or what was filed by or what was in the record by the plaintiff or produced by the plaintiff to contradict this notice of acceleration being sent by the prior holder, because the plaintiff in this action was not the original holder of the note. This note's been passed around and assigned some unknown time from one to who knows how many, but the plaintiff did not have anything, did not produce anything, cannot produce anything, would not produce anything. And I say that because if there was something to produce, such as an affidavit from the original lender saying we did not send notice of acceleration, then that would be in the record. The record is without, and it's devoid of any contradiction of Mr. Jackson's statement. The plaintiff did not demonstrate that the year 2008 acceleration was disputed. Now, there was discussion by opposing counsel with regard to how the response to the statement of additional material facts was addressed. It was simply stated disputed, and there was another sentence that went on, but no supporting affidavit, no citation to a deposition, nothing that would contradict what Mr. Jackson said, which was that notice of acceleration was received. It was just completely bare, unsupported, bare assertions of counsel. And of course, I submit to the court, and I believe it's, I've cited on page 2 of my brief that, a bare assertion of denial is not evidence, and it's not something that the court would consider to contradict a clear fact that acceleration occurred. And I guess we're lucky to some degree in this matter because the fact is straightforward, clear, and uncontradicted. Notice of acceleration was received by Mr. Jackson. The statute of limitations started running at that point. No countervailing evidence whatsoever that would contradict that. And again, there is no evidence. Now, I guess jumping ahead to some degree and suggesting why not take this to trial? Well, the whole purpose of motion for summary judgment is to determine whether or not there's a need for trial. And this is a way to cut down to the brass tacks, so to speak, and figure out, do we want to waste additional time in this proceeding, or is there any evidence that can be considered? And the answer in this case is there's no other evidence to consider. Otherwise, it would be in the record, and there is nothing in the record that contradicts the statement that was made. Now, obviously, under Rule 56, the defendant has the burden after we have presented our case as a moving party on this motion for summary judgment to produce some countervailing evidence, and nothing was produced. I'll make the point, too, that under I cited the Todd versus Shelby County, 407 Southwest 3rd, 212. It not on a critical issue, is it important, but it's not contradicted. Of course, if the the plaintiff in this case, the entity that was intending to enforce this promissory note, felt like there was evidence someplace in the world that could be identified, then a request for a continuance could be made so that depositions could be taken, or that or affidavits could be obtained from some unknown entity. But none of that, that's not the case here. So it really solidifies the fact that the record is clear in this action. It's not contested. The statute of limitations did run. It's also important to understand or recognize that after the initial ruling by Judge Fogarty in the trial court that the statute of limitations had run, the plaintiff filed a Rule 59 motion to alter or amend. And so we had a second hearing on this. There was no supplementation of the record to the court, just further argument, and we argued that issue again. Now, with regard to the statute of limitations, the citation of to the particular statute, counsel or the plaintiff in this case cited directly to the 6-year statute of limitations governing contracts in his initial response to the motion for summary judgment. I've cited that in our brief. So there was no question about which statute of limitation applied. And even if there was a question about which statute of limitation applied, it's clear that the statute of limitations ran, whether it be the 6-year contract statute of limitations or the 10-year catch-all statute of limitations. So that's really not an issue. But the underlying and basic point here is that in this case, the plaintiff had to set forth specific facts showing that there was a genuine issue for trial. Now, with regard to some of the cases that were mentioned by the plaintiff in argument and in brief, I submit that all of them are outside this jurisdiction in terms of, or in federal court. I think there may have been one case that the plaintiff cited that was within Tennessee, but it was a federal decision. I submit that the facts in all of those cases were inapposite. They were not applicable to the specific situation we have here, where we've got a clear specification that there was that there was an acceleration. And then to the contrary, there is absolutely nothing. Now, there are cases that were cited by counsel that address the issue of, can the court not accept an affidavit? Well, one of the decisions out of Texas, which was the factory case, it's an unreported decision from 2020, but it's out of Texas. The court disregarded an affidavit in that case because the party that had submitted the affidavit had previously submitted sworn testimony or pleadings that contradicted the affidavit. So the court doesn't have to accept an affidavit if there's any question about the veracity of the witness. Is there a question of veracity of the witness in this case? Zero. No, there's not. There's again, nothing to contradict what Mr. Jackson said and the evidence that was presented before the court. There are other decisions too, but if you look at all of those decisions, then the LHD Realty Corporation action is a federal decision. It was in bankruptcy case, and acceleration was argued to have occurred. Did it occur because of the lender in this case, who had a lien, filing a motion for relief from an automatic stay in bankruptcy? Well, the court determined that in fact did occur. Acceleration did occur because of the relief was being requested from the automatic stay. So that's a situation where you have more facts that are at play, and you have to take facts and the law and make a determination. But in this case, that's not the case. The Kreider decision, that was discussed by counsel, there was a letter that existed, and the letter was looked at, and it was determined that the letter said, look, we're going to do this or we're going to do that. And that was accelerate. Either you're going to make your payment or we're going to have to accelerate. All right. Well, that's not, I'm accelerating. That is, you have an option, Mr. Debtor, who's in the situation my client was facing, or in that position. But in this case, the instant case before the court, what was told to Mr. Jackson was, we are accelerating. That's the evidence before the court, and that's all there is. I would submit that the appellant's position is not substantiated. We would ask that the appeal be dismissed or overruled, the cost of this action be taxed to the plaintiff appellant. Be happy to address any other issues if the court has any questions.
I hear no questions. Thank you very much.
Thank you.
You have your rebuttal.
Thank you. I'll address the last point made by Mr. Hall that regarding the alleged acceleration. Here, Mr. Jackson did not say that the notice said that we are accelerating the note. He didn't say anything about what was actually in the notice. He just said he received a notice of acceleration. And it goes back to what I was saying, which is that simply even if the document, if we assume that the document said notice of acceleration, that in and of itself is insufficient given the case law that I have cited. And you combine that with the fact that Mr. Jackson didn't say in his affidavit that the notice he received said that the note had been accelerated, and we can't find acceleration here. Mr. Hall focuses on the lack of evidence that my client presented at summary judgment, but he neglects to remember that the burden was on him and his client at that stage. Again, the motion for summary judgment was filed before any discovery was taken, before an answer was filed, and so he then blames us for not presenting these documents that would, he hopes, help his client prove that it was accelerated, but that's not the burden. The burden is on him, not on my client, to help him in his quest for a motion for summary judgment. The Tafakuri case also, I'll read what they said in that case. A party's assertion that acceleration occurred is a legal conclusion. Again, it goes back to the statement by Mr. Jackson was nothing more than that, a legal conclusion, and not a statement of fact.
Thank you very much. I want to thank the attorneys for your presentation. Your case is now submitted to this court for resolution. You would receive our opinion within the due course of time. I want to thank you again for your presentation. Madam Clerk, will you call recess until the next case?
This Honorable Court of Tennessee